SJC-13850, Commonwealth versus Javaine Watson.
I'm going to just give you a second so that it...
Not for me.
Okay, Attorney Jordan.
Good morning, may it please the court. Darcy Jordan on behalf of the Commonwealth, and with me is the trial prosecutor, Ian Pollenbaum. Chapter 278A is a narrow exception to a long-standing principle of Rule 30. It has limiting principles already internally in it. Its limits, the terms are its limits. It is only to be applied to evidence that's capable of biological testing that leads directly to a connection between the material, evidence of the identity of the perpetrators. Digital evidence for impeachment purposes does not fit either of those components. What this does, if it does apply, that means that we're using 278A as a general discovery tool, which is not supposed to be used as, it would essentially nullify Rule 30 and essentially would make the exception swallow the...
How do you get past the disjunctive in the statute?
Turning to what we were just talking about here is about statutory construction and what the purpose of the statute is. This court only 6 weeks
Usually we
ago-
start with the words. So why don't you address Justice Gaziano's question?
Well, I think the words need to be interpreted with the purpose of the statute.
We don't get to that unless the words are in.
But this court has already determined what the purpose is. So to somehow say that we don't understand...
Well, we had before us, Wade, just the fact that we've had a whole bunch of DNA cases under 278A doesn't say that we've determined the purpose of it. We decide cases that are before us. But here you have a statute that has a disjunctive that has physical evidence or biological material, correct?
Yes, and I think I understand the...
So what in your view is physical evidence?
In my view, physical evidence means tangible evidence that's capable of being tested for biological material, because I think
That's the natural reading of that?
Well, I think the natural reading
What about
is,
gun? Wait. So we have in the past on the 278A firearm evidence, right? Ballistics evidence. Would you agree that ballistics evidence, shell casings and projectiles could be tested on the 278A?
I honestly, in my opinion, is that it wouldn't be, that this statute limits it to biological material. And if I could explain back to the terms of the statute and to answer about the conjunctive, is that biological material is defined within the statute,
Sure.
in Section 1, and it talks about exactly that, semen, blood,
So all the
saliva.
278A cases involving ballistics in gunshot residue, et cetera, were wrongly decided.
If we look at science and whether or not, we could look at if those chemicals, if it falls under here. But the question is, what does evidence mean vis-a-vis the words biological material? And I do think that we have to look at this court's already determination.
So you're reading it to mean, the statute to mean physical evidence consistent of biological?
Yes, because if we look at it this way, when the legislature defined what biological materials are, they defined it as that thing, blood, saliva, now hair, but they don't mean in the statute just a hair. It's not as if biological material is somehow free-forming. It is on items that need to be tested for the biological material.
Let me ask you a different question. There's a footprint in the snow. A casting is made of the footprint, never tested, right? And we have a whole bunch of perpetrators and third parties who are wearing sneakers. Is it your view that you can't use 278A to petition the court for testing comparison of the footprint?
Based on my reading, understanding of the statute's intentions, I think that it would be outside. Because if we look at what the legislator intended, it had to do with DNA evidence. It was a carve out of Rule 30. Now, the footprint evidence, that would be in a Rule 30.
Well, that Rule 30 isn't the answer because this is a difference. Legislature, as you said, it's a distinction. If Mr. Schnipper had Rule 30, we wouldn't be here, right? So if he had
Right,
the
but Rule 30, Rule 30 is the standard by which the legislature was carving out an exception that identified the advancement of DNA, of biological material.
See, the problem with your argument is the words of the statute and the fact that I think that we were like 49 out of the 50 states to adopt any of this kind of post-conviction broad testing. And some of those prior statutes of the other 48 states were specific to DNA. We chose, or the legislature chose to choose different words, did not say DNA testing. It said evidence or biological testing. So
I think that is back to my original understanding of the way the words work. And if we look at it contextualized throughout the statute, the only reading is that the evidence has to do vis-a-vis the biological material.
why would they say evidence or?
It's because it's talking about the evidence that's capable of testing for the biological material. Because
Those would have been very more specific, very different words, but they chose different.
well, I think they did it for the purpose of, to your point, making it as broad as possible to not eliminate items. So again, the idea is
Right, yeah. So how does that fit with your argument that it is limited?
because DNA is not a free-forming thing. It has to be contained in something. And by saying biological material, that contemplates a hair. Something in isolation is readily identifiable. But this statute meant to be the bloody sock that's sitting in an evidence locker of Boston police from 1980. We don't know, maybe, or a handle, a knife handle. I think of Clark, the case Clark, and that this court ruled on, where there was a knife that didn't have any blood on it. And this court was like, well, this is the potential. Biological material can be invisible.
But here's the problem with what you're saying, and I know you've been chomping at the bit, so please let me get my question out, including the wind-up. So you just said one of the reasons why, in your view, that you're taking this construction is because there have been advances in DNA testing and identifying DNA materials. You wanted to use the cell phone in this case. And one of the findings in this case is that the judge made was, at the time of trial, your expert couldn't do it, right? And you don't challenge that finding of the trial judge in this case. And we now know that the current state of the technology is we can do now what wasn't available to be done at the time of trial. So it actually fits in your rationale as to why 278 would make sense, because you have a situation where if you had the ability to do this at trial and it led to something inculpatory, you bet dollars to donuts Attorney Pallenbaum would be using it in his prosecution of the defendant. So why does it make sense now that we take this narrow construction of the statute where it was designed to help defendants prosecute motions for new trial?
Because it was designed to address biological material, not cell phones. Because when the statute was enacted, Rule 30 was in place. This was a narrow exception. The reason it can be so narrow is that there's self-limiting properties within it. If not, it can't be this remedial statute. That means everything would be encapsulated in it, and that would swallow Rule 30. So that means that given the lower standards, which we all acknowledge that this is intentionally narrow to allow defendants to get this kind of affirmative evidence of innocence that can be found in this binary finding of a match, no match, and to somehow say that that lower standard should apply to cell phone evidence, digital evidence that's not physical, not material, I think would dilute not only the legislature's purpose, but what this court has already determined, that it's an isolated thing that goes to biological material. Now, it's reflective of the science. Now, I don't disagree with you that
Well, go back to that then.
Sure.
What is your best case to say that we have said that evidence in the context of this statute means only biological evidence?
In Tanner, 6 weeks ago, I'll read from Tanner, this court said, the legislative stated purpose in enacting 278A was to remedy the injustice of wrongful convictions of factually innocent persons by allowing access to analysis of biological material with newer forensic and scientific techniques to provide a more reliable basis for establishing a factually correct verdict than evidence available at the time of the original conviction.
That's consistent with the statute not limiting. I mean, that certainly is, I don't think anybody's
But-
arguing that part of the statute wasn't enacted for the retesting, updated testing of biological materials. I guess I don't understand how your position doesn't read out the evidence part.
Because if it is not limited to biological material, then it is limited to nothing. That
No,
means
that's not exactly true, because there's another limitation in the definition, which is the testing needs to be to identify the perpetrator of a crime. And that seems to me to be the animating principle behind the statute, which is not testing of all sorts for any purpose, but testing that may bear on the identification of the perpetrator. So, so it seems to me that in arguing an extreme view or, an absolutist view of the statute, that it would be unlimited, that's not really fair to the statute. And so perhaps it would help your argument if you acknowledged that the statute is otherwise limited in a very important way.
So I understand your point, and I think I don't mean to be absolutist. I mean to say that this was an absolute carve out of biological material and it has to be compared.
All right, so
as
assume
to
that
say,
we were to give meaning to the word evidence and meaning to the word or, and conclude it's not simply limited to biologic material. What next?
What next? Then it would turn to what does materiality of the identify the perpetrator. In Ramos, this court has already decided that it means significant evidence of that, and that is not what impeachment evidence that this defendant seeks to use it as, which means whether or not this witness was lying or not is not determinative of or cannot reveal evidence of.
Well, we've taken a pretty generous interpretation of this, right? We haven't interpreted it in a limited way to, oh, you didn't do it. We've interpreted it in other, I can't remember the cases. The chief has written most of them, but we've talked about self-defense. We've talked about third party. We've not.
So I'm happy to distinguish all of those. This is not a self-defense case, so I think that's distinguishable in that in the self-defense cases.
Well, it's a new technology. It's a new technology providing a material information to the verdict.
Right, but if we can just tease out what that means when we're talking about impeachment material, and we have to look at vis-a-vis what the narrow exception was of materiality of the perpetrator. Now, when we look at what impeachment evidence does, it's to discredit somebody, to say someone is lying, the jury should not believe them. But that does not mean
Doesn't that go?
But it wasn't. I think there's a mischaracterization of the record and this witness. This witness was a resident witness. She was not the key witness, this damning evidence that my brother portrays her to be. It was clear when she testified that she was distancing herself from what she is now in a homicide case, and it also, in a way, insulating the defendant. She was basically saying, I didn't see him at the club. And what the defendant omits, as did the judge below, was that actually Watson admitted to being in the club. It's a Commonwealth Appendix 287. He actually told police that he was there, that it was not used at trial for other legal purposes. But I point out that that corroborates Omarosa's testimony that she said that he was there. And it also corroborates that he was with the 3 co-defendants that night. So to somehow say that her testimony was perjurious.
That's more of a motion for new trial argument.
Exactly, and I think that's what I was getting getting at is that if we unpacked what this evidence does, the essentially is saying the Commonwealth's case is weak, and that is a Rule 30 motion. That is not a 278A that says, it's almost I don't want to say it's binary, because I know that treads into what this court is saying, but it's this idea of, can this test provide affirmative evidence of innocence? Is it something where that's why we want easier access? And frankly, a lot of these 278As we agree with. The Commonwealth agrees and says there is affirmative evidence of innocence that could be tested on this biological material. We want it too. And that is not what this statute is meant to be
The
used.
defendant made a Rule 30 motion, did he?
Sorry?
He sought the discovery under Rule 30 as well, correct?
Yes, but the judge after this hearing deemed it moot because of this.
So is your position that this should have been allowed? What was the Commonwealth's position below on the Rule 30?
The Commonwealth's position is that the defendant has showed no new evidence to essentially say that this person is a liar, and that these
Isn't that the catch-22 that 278A was designed to?
well,
I know that you're focused on biological
No.
material, but
I think what happens is that, again, we're merging the exception with the rule, because what Rule 30 says is that if you have credible evidence to show that this could lead to a motion for a new trial, then your evidence should be allowed. But that's not what we have here. We essentially have the same evidence that was deficient in him showing a probable cause, a nexus between the phone records and the crime that was denied below. Now we have a Rule 30 motion where everything now, the burden's on him, where now now we're saying that's equally sufficient. Right, but that's not how Rule 30 works.
Rule 30. So in order to animate the Rule 30 and say, here's the reason why, I've got all of these text messages, I've got all of these conversations, not between me and my guy, but I have it between her and the person she was trying to protect.
Right. And all of that, if I may, all of that evidence was before the judge that ruled on the phone, on the motion for the phones. And more importantly, all of that evidence was before the jury. And what they did was discredit, really what this amounts to is a repackaging of the defendant's attempt to relitigate a credibility claim that he finds to be adverse. Basically,
I understand we're gonna have some very tough questions for Mr. Schnippers too, but his point is essentially, if I get access to all this phone message, I'm going to show that Amoroso is the girlfriend of, I can't remember his name, Robertson, and not my client. And Robertson rented the car, not my client. Therefore, my client was and he's got some problems because we got his phone in the car and a lot of other things. But his point is, new technology will reveal that Amoroso was lying because we're going to find texts, 30,000 texts between him and her and Robertson. And why isn't, again, this thing just gets you in the door. Why is the sky going to fall if that happens?
I don't think the sky is going to fall, but what we're talking about is finality of judgment, and Rule 30 protects. And frankly, the door that is opened by Rule 20 or Chapter 278A. And the proposal that you just gave me is basically the same evidence that was deficient below. And I suggest, as I suggested below,
He didn't have it.
was that if there is additional affidavits, if there's additional.
By the way, I'm worried about the Pandora's box that opening up every phone. I get it. There's a problem here. But the legislature didn't do what you said. They could have created a DNA statute. They have a much more open statute. I'm trying to figure out, how will all hell break loose?
Well, I think, again, I think if we turn to the first part of my brief that talks about the internal limiting purposes, it's like contract law. When we read the statute, how is the word evidence being used? And it's only being used as it returns to a physical item. And I say it's because it has to be interpreted with the purpose of the statute.
The phone is a physical item.
But it would be different if the phone was being tested for DNA, if it was a swab, if there was an allegation that the offender held the phone.
I get the point that it has to be evidence, in that you wouldn't have a 278A motion or someone to try to seek a PET scan of someone post-conviction, right? Because that doesn't exist. It's not a thing yet. Or to have psychological testing of a defendant, right? That's not evidence. But here we have physical evidence that's going to be tested through.
But it's not for a biological
I guess
reason.
that's what now we're circling back to.
Well, we're circling
to what the "or" means.
I know we're circling back.
But what makes your interpretation make modern technology obsolete? I mean, if we take the construction you're talking about, all of these new advancements in how we get evidence, we unearth evidence, you're saying that all of
No.
this is outside of that.
I absolutely do not. I think that sounds like a great newly discovered evidence claim under Rule 30. I think that sounds like it belongs right where, when the legislator passed this to say this narrow exception for DNA, biological.
But the facts of this case demonstrate it's not newly discovered because your expert couldn't extract it at the time of trial. So it was already there, but it wasn't attainable.
But I feel like we just crossed over. That is not what happened. These phones weren't evidence in this case. These phones belong to a defendant, and the co-defendant in other cases. So the Commonwealth also wouldn't be able to get into these phones because there was no nexus between the murder. So it's even more removed than your proposed question.
Two of the phones the defendant did try to get to, and Judge Roach denied the motion, correct?
Right. Yes, and so I guess my point is, it's not as if our expert tried to get into them. We're essentially legally precluded from doing it where there's no nexus. So we're looking at, how do you get evidence that wasn't in this case that belongs to somebody else? Again, not biological material, not evidence in this case, and basically reconfiguring a claim that tries to address the credibility of somebody that doesn't directly
Let me just ask you factually. I mean, like in every other case, you had 4 defendants in this case. You took all the phones you had, and I get there's some issue with the iPhone that was not attainable back then. But you took all the call logs and the CSLI, and you matched them all together. And I wrote Bonner, I get it. But you did that in this case, correct?
Correct.
So how is this evidence not obtainable?
These phones were not evidence in this case. The phones that belonged to Robertson
chose not to.
are
There were certainly evidence in Robertson's case, right?
right, but
Or where he was and who he called and how he contacted. And
those-
the 4 people were in collusion right
those
before and
cases
after.
were not this case though. Those were recovered on 2 separate instances and nothing to do with this. One had a case where Robertson was being shot at, and another was when he had a home invasion. The police showed up and there was drugs all over his house and they collected them. So there's no nexus to this, which again, I think again puts us back in Rule 30, not the exceptional circumstance that the legislator was contemplating of how, just like we said, that you said in Williams, the whole purpose is to facilitate.
3 of the cell phones were seized from Robertson during his murder arrest 2 months afterwards, right?
Right, but
Those, and you got the call logs from those.
But that was when the police showed up for a different reason. And again, no nexus to this murder case. So this idea that our experts couldn't get into it, I think what Justice Georges was talking about was at the hearing where they were talking about those phones that were connected were not accessible. But it's not as if we tried and we couldn't get it. It was that there was legally deficient evidence for the Commonwealth. Moreover, the defendant didn't even try to get all of them, but also legally deficient for him. So now to somehow say that advances in technology somehow, it's essentially an attempt to repackage a credibility claim that didn't succeed at trial, i.e. Omarosa was lying. It's repackaging it as a prosecutorial conduct, somehow saying that the Commonwealth saying that put on Omarosa who was lying, and there's no evidence then or now of that. And then also reconfiguring it into this exceptional rule that is supposed to be narrowly used, in which it doesn't apply.
Can you clarify the facts for me a little bit, please? The whole theory is that if we get all these cell phones, it's going to show that Omarosa and Robertson had lots of calls together because they're boyfriend and girlfriend.
So yes, so
but like the timing of it, if I recall the record correctly, when she was the girlfriend of Mr. Watson was for a shorter period of time. So why do we care if Robertson was talking to Omarosa 5 years before?
So the relationship, I think, was I think the testimony was August or September, and that might be. But I think if we can also just pull back even further.
But why don't you stick to Justice Garcia? I'd like to pin down. So I'd like to understand those facts too, because I have some questions because I'm not exactly sure what this is going to show. But so if the cell phones are from how How long before the murder?
So the first set of cell phones before the murder happened in the summer. The relationship is alleged to have begun between August and September. The murder happens in December, and the second set of phones is recovered in February. So to answer the question, they could have.
Both before and after.
That's correct. And then there's also testimony that the phone that Robertson used during the murder was terminated the day after the murder. And so this was part of the reason and rationale why there was no legal access to get to the phones.
But Robertson has
after.
lots of phones.
Yeah, well, there's lots of testimony that Watson had 2 phones. There's testimony that Robertson had 2 phones. So this idea of damning evidence on the phone, I don't know necessarily pairs out. But if I can turn back to your question. So the answer isn't, I don't know, what could it be? The answer is, what does Rule 78? It really comes down to what is the small silo that it's supposed to address?
Well, I'm just looking at it in context of whether or not this would be so significant as to call into question his identity as a perpetrator.
It very well might not be, but either way.
Oh, but that's a bad formulation.
No, well, I think
it might very well not be.
I think my point has to go back to the language of the statute that talks about materiality of the perpetrator and
So, like, whether or not Robertson was boyfriend and girlfriend with this woman 4 years before the murder, I don't see how that has any relevance whatsoever.
Sure. Yes, right. But also, it clearly, because we're having this conversation about what does this mean? How does it mean? That means it squarely doesn't fit into the small, limited reason of materiality of the identifying of the perpetrator. The fact that we're engaging in this grappling of what does it mean is illustrates that it's a Rule 30.
That's a question for Mr. Schnipper.
So, I agree.
Thank you for your time.
Thank you. Okay, Attorney Schnipper.
Good morning, Mayor of the Court. Merritt Schnipper representing Javaine Watson. Before I launch into my prepared remarks, I want to stridently object to the idea that evidence of perjury in a government prosecution for a capital offense is mere impeachment evidence. That's not what it is. Impeachment evidence is padding your resume. It's lying about whether you had a couple drinks the night before. This is evidence that Nadira Amorosa, the only witness to testify that Mr. Watson was part of this plan, sat on the witness stand and said, no, that man, the man that I have 312 phone contacts with in the month before the offense, I've never seen him. 88 Palomum stood behind Andrew Watson and Robertson, and said, have you ever seen this man or spoken to him outside of court? And the response was no. So I think it raises a pretty significant question. What on earth this witness doing, sitting on a witness stand, saying that she's never met a man she plainly has been communicating with constantly?
Let's talk about the timing.
Sure.
So as far as these 5 cell phones go,
Yes.
and the murder itself, are these too remote in time? Are they right on time? Give me some sense of the timing.
They're definitely close enough in time to provide potentially material evidence to identification, and here's why. So 2 of them, and these are the 2 that the government has already searched and has the search results for. In other words, it has the ability to know and may very well know whether Mr. Robertson and Ms. Amorosa were communicating, but we have not been privileged enough to get that evidence yet. So 2 are from 5 months before the offense, and 3 are from 2 months after the offense. All right, so the theory here is that the phone at issue that Ms. Amorosa was supposedly using to communicate with Mr. Watson, but at which it's undisputed that Andrew Robertson's live-in girlfriend paid for, canceled at his request the day after the crime, and she herself communicated with 224 times in the month before the crime, but denied from the witness stand that she had any idea who was using it. In other words, another instance of perjury in the Commonwealth's case. So the principle here is that those phones show 278 communications between Mr. Robertson and a woman named Tamika Edwards that he has a child with, 73 communications between Mr. Robertson and a woman named Simone Lopez that he shares a child with, again, 224 communications with Ms. Nelson that he lives with, 312 communications with Ms. Amoroso, and then 203 communications with Javaine Watson. So this whole idea that DNA is this unique magical identifier.
Push you just a little bit, because
Sure.
I see your point. But I get lost a little bit when I realize the defendant's phone is in the car.
Sure.
So what are we, the defendant is at the scene of the crime where we've got this sort of assassination by two vans. So help me out here.
Sure.
If she's lying, we know he's in the car, right?
Let's think about it this way.
Or are we suggesting someone left his phone in the car?
Well, I'm not suggesting anything because I'm not at the Rule 30 stage.
Okay.
I'm acknowledging that there's significant forensic evidence tying him to this vehicle. Okay. And
His fingerprints are in the car. His phone is found in the car right after the event.
about an hour after the event, yes. So
What are you, this proves just what you say, that Amoroso is having a relationship with Robertson.
okay.
What is that?
Well, let me ask you this.
What is I get it, there may be lying, but what does it get you in this case? Because this is a case in which his phone is in this car and this assassination is clearly well planned. Because you've
Sure.
got two cars converging on the shooting. So, it's not rhetorical. Because
I mean,
your
it's
brief
kind of
is,
rhetorical.
your brief is very, very, it builds momentum, and I start going there, but then I come to this and I say, wow, maybe there's nothing here. So tell me why I'm
There's a
wrong.
tremendous amount here. So let's start out with what this court said in Ramos a couple of years ago. And it specifically rejected the government's argument that materiality to identification was judged by assessing the evidence that was sought through 278A in light of the trial evidence. So the court has already rejected that idea, right? Number two, if you want to frame somebody for a role in a crime, would it be better to frame someone that you have a lot of knowledge of where they were and what they were doing so you can tailor your story to those facts? Or would it be better to just guess about somebody who might have been at an amusement park that
I
day?
agree with you, but he's there.
Fair enough.
He's in the car. So
There's evidence connecting him to the car. The government is required to, at trial, if you want to use fingerprints or other forensics to tie someone to a device using a connection with a crime.
I agree
Can I just
with,
finish my
I agree with
answer?
that. Sorry, yeah, but let me just I just want to load it one more time.
Okay.
I agree that his fingerprints aren't showing he's there, but let me add this fact. We never leave our phones. Our phones and us, we've written 20,000 cases saying they're inseparable now. So when his phone is found in the car after the shooting, and I promise I won't interrupt you, deal with that fact, okay?
Sure. Okay, so the strength of the Commonwealth's trial case doesn't matter under 278A. That's the first fact to deal with. The second thing is that the government is required to prove, again, we're not talking about whether the government has a sufficient case without Nadir Amoroso to take Mr. Watson to trial and overcome a motion for required finding. That's not what we're here to talk about. So do you want me to acknowledge that this is damning and harmful evidence that we'll have a serious challenge dealing with at the Rule 30 stage? I acknowledge that. And that's an excellent segue to what my sister was erroneously talking about. 278A is not a carve-out to Rule 30. It's an entirely separate statute that was enacted based on a recognition that the Rule 30 construct that had been developed over many years through a lot of very vigorous litigation by the Commonwealth effectively prevented people like Mr. Watson, who's spending every day of his life until the day he dies in prison, from investigating their cases. So what they did is they said, we're making something completely separate from Rule 30, so you can do this investigation and nobody has to worry about that judgment. Right? A jury found you guilty and you're staying there. But I just want to finish and then I'm ready for the questions. But you were the only mention of Rule 30 in Chapter 270A is in the discovery portion that says you shall not apply the Rule 30 discovery standard.
I get the purposes of 278 versus Rule 30. There are a few people who had stronger evidence against them than Robert Wade, and we said it doesn't matter.
Correct.
On the Section 3B5 findings,
Yes.
why you didn't test it. We have the technology. I get maybe there's the only exception is the iPhone, right? But we have all the other phones. We had the ability to get call logs and CSLI through all those things. So the finding under 3B5,
Sure.
I'm not quite getting it. It may be that, well, it might be the last factor that the attorney either failed to seek or the judge denied the request.
Sure.
I don't get the other one about the new technology, but maybe it might
Absolutely.
be the latter.
So let me just, that's true. So the judge he found that we had satisfied multiple prongs of
Right.
that. So in terms of the reasonable attorney prong, he found both that trial counsel sought access to 3 of the phones by motion, but was denied. So we satisfied that prong. And that a reason, excuse me, in light of Watson's unquestioned trial defense of saying that Robertson was Amoroso's girlfriend, not him, that she was lying, that a reasonable attorney would have sought all 5. So we satisfied that. And with regards to the advances in technology, what you would note that at the trial, there were 3 phones, none of which were capable of being a full Cellbrite download completed on them. SIM cards were available. Stephen Veronneau, who testifies at the hearing, says, okay, basically now it's guaranteed we can get into all those phones other than the BlackBerry because of the development of a forensic tool known as brute force that was entirely developed since the time of this trial. That just helps overpower passwords that gain you access. So access, again, based on hearing testimony he credited, the judge found that there had been significant advances in technology in terms of access. Then once you're in, the question is, what can you find? And there's no question that call logs were available from SIM cards then, and call logs are available from SIM cards now. But the question is, what else can you get from the actual device? The records are gone. Only the devices remain. And what you can get is location data. You can get timeline views that show where were you.
They had location data from before, though, right?
Not from a SIM card. You had to get into the phone itself.
Right, but back then, you had CSLI was available.
Through records requests,
Right.
yes, yes. But the point here
I
is,
guess it may not matter because you have the.
well, I just think we're
the
kind of in the
fourth-
belt and suspenders territory on the Section
Right.
3B5 findings.
I guess we don't have to waste anybody's time if
No, I mean, it's not a waste if the court has questions. I just think we overwhelmingly satisfied that factor.
And just to put a finer point on it, is there any argument that the BlackBerry satisfies this prong?
Well, excuse me, with regards to the BlackBerry, you mean the technological advances prong? No, I don't think so.
So we have to reach, if we were to uphold the judge on the BlackBerry, we'd have to reach the attorney that should have requested and/or.
Yes, because that was the only way for counsel to get it, was to have his motion allowed. The government controlled access to those devices. And one of the things I think that really should concern the court, frankly, is that at the motion hearing, the government specifically said, we really want to see what's in those phones too. And the only reason they don't want to see it now is because Mr. Watson is where they want him, and this evidence is going to demonstrate. Again, I'm not accusing them of knowingly suborning it. I'm talking about.
it sounded like you did.
Well, they're looking away in the face.
Let me ask.
Looking away in the face of flashing lights, warning about perjury for sure.
No, and the last question I have for you, I hope, is that what about the rights of Robertson?
A few points to make about that. The first is that Mr. Robertson was represented by counsel at this hearing and made what opposition he chose to make. It was overruled. I made an argument that he had abandoned the phones, which the judge declined to reach, but just because he found that we had justified the actual search, but said that our arguments had some force. I agreed that they did. He filed a notice of appeal, but chose not to participate in these proceedings. And then, of course, Chapter 278A itself requires protective orders to shield the dissemination of information obtained through the forensic analyses it permits, unless and until they're used in a court proceeding. And in the actual order that Judge Pino issued, he specifically required the parties to work together to propose a joint order that accounts for the need to be considerate of those considerations. So those are all areas in which Mr. Robertson's rights, to the extent he didn't sacrifice them by abandoning these phones for 10 years, can be accommodated, let's just say. But again, when we talk about timeline, let's just talk about this timeline. Let's talk about the timeline in February of 2014. And let's talk about what happened on December 19th, 2013, when Ms. Amoroso is at the grand jury accusing Mr. Watson of doing all the things that he now stands convicted of, or at least in part based on her testimony. So the question is, if we accept the strong inference that's presented by Mr. Robertson's existing phone records, which show him communicating, 550 times with 3 women in his life in a single month on his phone, and another 300 times with Ms. Amoroso, that's an 870 woman, 4-woman text chain that he's got going. If we have phones that show the similar pattern of use, and of course these phones are blueprints of our lives in a way that's very analogous to DNA evidence. I'm the only person who texts and phones the 10 closest people to me in the world. If you get that phone and you figure out who knows those 10 people and those types of relationships, you've got me. So if you get a phone from 2014 and it has the...
What is the limiting principle under your interpretation? I mean, the Commonwealth seems to be concerned about this Pandora's box. Every piece of evidence is going to be subject to this 278A. What's the response?
It's what Justice Wolohojian raised. It's materiality.
Because it has to be shown.
It's materiality, and it's the reasons that testing was not performed before trial. So the question about is there...
materiality to the identity, right?
Right. Materiality to
identity. That hurdle is not high, is it?
It's not high, but it has to be focused on identifying this individual. I mean, here's a perfect...
These are trash by the roadside, right?
Well, obviously, Moffitt didn't make the cut because there was no shown connection between the perpetrators, no potential connection between the perpetrators. I mean, again, nobody was saying that DNA testing of a cigarette butt found by the side of the road isn't permitted by Chapter 278A. The court said you haven't shown it's material, or really appropriately for here, because we're the prevailing party, you haven't showed that the judge abused his discretion in finding it wasn't material, right? So here, of course, the government has to show the judge abused his discretion in finding it was material.
But what about like the phones of any potential third-party culprit?
Well, how do you demonstrate the role? I mean, you have to show, what we're showing here is that the trial defense of Watson and the trial prosecution by the Commonwealth was all focused around what was proved by phone records, right? So, I mean, in another case in which both parties are focused on what would be proved by another person's phone records, and those phones are then susceptible to 278A analysis because they're held in evidence for 10 years, yes, they're accessible for that purpose. But the truth is, you know, I didn't really get to talk a lot about statutory construction, but this is quite possibly the broadest statutory language I've ever read in the definition of analysis. So it's a bit
Could you finish, just expand on Justice Stewart's question. So you have a third-party culprit case.
Sure.
For whatever reason, the third-party culprit had been arrested and a phone seized. Could you use the statute to say, I want to look at this person's phone to see what CSLI says, to see where this person was on the time of the murder?
I really think that would depend on what other evidence of that person's presence at the scene there already was, because you have to come forward with some showing that shows why materiality would be established. And here we've come forward with a very robust showing that there's a network of relationships on the one Andrew Robertson phone we have in evidence that maps out a very intensive Andrew Robertson-centered universe in which Nadira Amoroso is a participant. So based on that, and based on the fact that the trial theory of defense was completely focused on showing that she had a relationship with Mr. Robertson, yes, we have made that initial showing.
Where the relationship was denied.
Where the motion was denied? And the relationship was denied. Yes, and our motion was denied. So, right, the relationship was denied, right? And the relationship isn't simply denied, right? It's denied in favor of claiming a relationship carried on over the denied relationship's person phone with his associate, who, again, you know, materiality to identification of significance is demonstrated in part by showing that the evidence could be used to contradict the narrative of guilt that's told by the Commonwealth at trial. Well, here we also have a narrative of guilt told by Andrew Robertson at trial. I mean, if you were willing to look at this record the same way, you can see flashing warning signs of the fraudulent misuse of the judicial process for purposes of presenting perjury. Andrew Robertson's counsel is up there saying, just telling her, so you think it was 8764 is the number you're using to communicate with Javaine Watson, right? Because he's the one who had your car that day, right? Okay. Based on that, based on what I would just say an objective view, and again, Judge Pino is not like in our corner. I mean, we made a showing at the hearing, right? He judged the evidence that we presented. These are flashing warning lights that for whatever reason, Mr. Watson's co-defendant is using a person who's easily at hand to him to try to point evidence away from him. Because don't forget, at the time that Nadira Amoroso was at the grand jury accusing Mr. Watson, they haven't found the photographer who was at the nightclub yet. They don't have the photographs of Andrew Robertson yet. They don't have the photographs of Omar Denton and Omar Barner yet. Of course, there is no photograph of Javaine Watson. But so at that point, Andrew Robertson probably really could entertain the possibility that he could get away with this. Right? I mean, that's what we are confronting here. And all we are asking, we're not opening any floodgates. We're not challenging his conviction. We will challenge his conviction when we get this evidence. But right now, we are just saying we have satisfied a set of statutory factors that the legislature put in place to make it relatively easy to use forensics to show that you were wrongfully convicted. And I don't think it's just happens to be the fact that a statute endorsing the exculpatory power of forensics is enacted by our legislature at the same time as this court is commissioning the study group, and we are seeing a major realization of the deep flaws in eyewitness identification testimony. You want to talk about the context in which this statute was enacted?
What about counsel's argument that evidence doesn't mean this type of evidence?
So, evidence is quite possibly one of the broadest terms that's used in the law. So I just don't think that that argument has any basis in the statutory language or in common sense. And we don't even have to get to the sort of like canons of construction about remedial statutes, of which, of course, Mr. Watson is a member of the intended beneficiary class. And I would actually note that in section 7C, the discovery provision related to the hearings, they actually, instead of evidence or biological material from a third party, it says items. All right, items, right? What is an item except something that hasn't yet been introduced in evidence, right? The only thing that's eliminated by items, and that does support the idea that you need a physical object, is testimony. Testimony is evidence, and obviously you can't really apply an analysis to that. I mean, you probably could, but we're not here to talk about that today. So I just think, all I'm really saying is we're not asking for some major shift in the law. We're basically identifying a form of forensics that has not yet been found to be available under Chapter 270A, but which the statute's plain language easily encompasses. It's not even close. And then the question of significance to identifying him, I just respectfully disagree with the idea that when only one witness provided testimony about Mr. Watson's purported participation in the events surrounding this crime, and we can show not only that that person was perjuring herself while hiding a relationship with his co-defendant, whose own trial strategy is to attempt to direct blame to Mr. Watson. The judge did not abuse his discretion in finding that evidence not only of her calls with Mr. Robertson and her texts with Mr. Robertson and maybe some selfies with Mr. Robertson and maybe some fact that Mr. Robertson tries to delete his text message with her, and that stuff isn't of significance to determining whether he was appropriately identified as a perpetrator of this crime. I just don't think it's a close case. So on that, I will ask that the court affirm the Superior Court's order. Thank you.
Thank you.